Okay. Good morning, everyone.
Good morning, Your Honor.
Right.
Good morning, Your Honor.
Good morning. So we have just this case for Zoom oral argument today. It is State versus James D. Marcia. Is that how it's pronounced?
Yeah, DiMarcia, I think is the way. Yes.
Okay, and it's case number C230380. For the appellant, we have David Hoffman, and for the appellee, we have Alex Havlin. So Mr. Hoffman, would you like to reserve some rebuttal time?
I'd like to reserve 5 minutes of time for rebuttal, please, Your Honor.
Okay, and I will let you know when you have 1 minute left of your initial 10.
Thank you.
Whenever you're ready.
Okay. May it please the court, Mr. Havlin, I have 2 assignments of error in this brief. I'd like to discuss them both in order. And before I begin on the first assignment of error, I wanted to discuss the standard of review a little bit. I understand that the standard for the first of the 4 cell factors is de novo, and the other 3 factors are reviewed under a clearly erroneous standard. And I believe the most helpful way to understand the clearly erroneous standard when it comes to fact finding would be from the Megan's Law cases, the appeals from Megan's Law, where the judge had to make findings and classify offenders, and the clearly erroneous standard applied to the appeals in those cases. And it said that as long as there's some competent, credible evidence to support the finding, that the finding was not clearly erroneous. And I think that would be, there's some confusion about the standards in this case, and I think that would be the best way to look at these findings and to discuss them under that clearly erroneous standard. I didn't want to discuss all 4 of the factors. I wanted to discuss the second factor, and that
just
factor.
Mr. Hoffman, just to be clear, so that I understand your argument, the trial court issued a written order with all of the findings, but you're arguing that the record does not support the findings?
Yes, I'm arguing that there's no competent, credible evidence with respect, at least this morning, I'm arguing about the second finding, but that is the gist of the argument, yes, on the first assignment of error. The Supreme Court of the United States said that it should be substantially likely that the medication to be forced on the defendant works. And there needs to be some evidence that if you're going to force this medicine on somebody, that it works. And the witness basically said he would hope that it would work, which is not the same thing. And or he testified that it might assist in the competency proceedings, which is not the same thing. I mean, if you're going to
question, Mr. Hoffman, and
yes,
maybe Mr. Havlin can answer this too, but I guess I'm a little confused on exactly how this works. So let's say you have this order of forced medication and it restores the individual to competency. He then goes to trial, he's found guilty and sentenced to whatever he's sentenced to. Like, does the order for forced medication continue during his incarceration? In other words, does he continue to get the drugs while he's incarcerated, or do we stop giving him the drugs then, and then we put someone into prison who has medical needs that aren't being addressed?
I'm not I don't know the answer to that question. I would suspect that they're no longer acting under that forced medication order at that point.
Yeah, I mean, is there a duration for that order?
I don't know. I would suspect that the duration is just until there's a conviction, but I honestly don't. I've never thought of that, and I don't think there's any language in the order that indicates that it's only for a certain time period.
I mean, because if someone gets restored to competency, it's not like poof, they're magically cured at that point in time. It means the drugs are doing the work that the doctor thought they were doing. And then there might be clinical reasons to prolong or modify treatment after that, depending on the unique circumstances involved. But I guess that's where my question about like, how do we read these orders, and what is the limiting principle of any of them?
I would think that after restoration, a person may still not want to be restored. It's possible. Just the fact that they're restored may not change their mind.
I think that's probably very likely in some circumstances.
Particularly if the side effects are severe. And so the need for the order may continue if a person refuses to be medicated and it could cause a problem in the institution where they're serving their sentence. I guess I could see that an order of forced medication might be something that would be needed. But I'm not sure about the duration. I'm not sure about the findings, whether the findings would continue to be accurate after the passage of time. I don't know. I'm sorry, I can't help you with the.
Going back to you were talking about the second factor, and I think you were discussing that, I guess one of the sub factors was not met.
Yeah, there are two factors. One is I'm painting with a wide brush, but it's basically whether the medicine will work. These are considerations.
My question is, and you can help me with the record. I thought he was on Risperdal previously.
That's correct.
Okay, and so you're saying there was no testimony that was helping him previously?
I don't remember any. No, I thought that the doctor said that he had previously been on Risperdal, and
wasn't there testimony of what Risperdal is for, what the effectiveness of it is for, and what it is prescribed for?
Yes, there was. Yeah.
And why is that not sufficient?
Well, I think it's not sufficient because there has to be some testimony that in this case, it's substantially, they use the term substantially likely that it would restore the person to competence. And the United States Supreme Court in Sell versus United States was specific that they said that these findings need to be case specific. It can't just be general. And I think that under the standard, the very lenient standard, a witness could say that he believed that it would work. I mean, he could say, I believe it might work. And that might be enough. What's that?
I thought that's what he said. I mean,
no, he said he didn't quite say that. He said, I hope it would work. And
this is a case where the defendant is not taking medication and they're asking to force it on him. So there would, in a lot of situations, there might not even be testimony that they tried this on the defendant before. So what kind of testimony would you expect there to come out of this if he's refusing to take the medication, except for a doctor saying, this is the type that we give for this indication, and this is typically demonstrates good results?
I think it has to be expressed in terms of probability or likelihood. I think a witness just can't say, I hope it'll work. I mean, that's the gist of what he said. Or he said it'll assist in competency proceedings. I think it's so easy to simply track the language of the court's case and asking a question that it's, I mean, I don't know why it can't be done. Just to use the word substantially likely and see if the witness will answer affirmatively to it. I just don't understand why it couldn't have been done in this case. I don't know, but it wasn't done. And the witness did not express himself in terms of a likelihood. And I think in any other area, if a person says, well, I hope this will work, that just won't do it. A mechanic won't say that about fixing a car.
Well, but I thought that there was the notion was that if that drug did not work, that there were some subsidiary drugs that the doctor would then go to to try to accomplish the desired result. So in that sense, maybe the doctor doesn't know for sure whether the first one's going to work, but he has a couple of different options available to him if the first one doesn't work.
I think that's possibly one way to read the record. Yeah, that it's possible that he had, I think he said frontline medications and then backup medications, and he had that was the plan. I think that he also mentioned the medications that were possible in the case of side effects, that he had some medications he could use if there were side effects. But again, he didn't express the likelihood of side effects or that it was substantially unlikely that there'd be side effects. All he said was that he had some medicines that he could use if there were side effects. And again, I don't think that was, I think if this could have been organized a little better, I think it would have been a very simple thing.
Attorney Hoffman, it seems like some of your arguments are going to the fourth factor in cell, with regard to, particularly with regard to all of the backup medication and the side effect medication. So what is our standard of review on that fourth cell element?
That's also clearly erroneous, Your Honor.
Okay, so that's clearly erroneous. So what is your position with regard to not to the Resperol, but to the backup medication and the side effect medication and the record, and how would that factor into that fourth cell element? So the fourth cell it requires the trial court to determine that the administration of the drugs is medically appropriate.
I thought there was testimony on close to hitting the nail on the head on that. I thought that there was the term appropriate was actually used, but
well, I'm talking about all the other medication. What was the testimony in the record on all of the because there was a litany of, it was 30, wasn't it like 30 something medications that were being requested?
Yeah, you're right.
Was there a presentation on every medication as to what it was for and why it was appropriate?
No, Your Honor, there was not. And that was part of my claim. I thought that it was, I think there were 33 medications in this attachment, and they just didn't discuss it. I thought to a degree that would allow a finding that these other medications could also restore the defendant to competency. And I thought that if we don't want to do this piecemeal, that it shall be done up front, that there ought to be a review at this hearing on all the drugs, so that it wouldn't be necessary for the physician to return again and again to the trial court for another try with a different drug.
Did the trial court allow for all of the requested medication to be approved for a forced medication?
Well, that's true. The trial court did. The order does allow for all that. That's correct. If there are no further questions on the first assignment of error, I'd like to move on to the second assignment of error.
Mr. Hoffman, you are beyond your initial time, just to let you know.
Oh, wow. Okay.
We asked you a lot of questions, but we did let you go over your initial times.
Okay. Well, I really don't want to wait. I don't want to sandbag my Mr. Haviland, so I'd like to discuss it just a little bit.
Go for it.
The sign-off requirement in the forced medication section is not like the time limit requirement. Time limit requirements are directory. They're directory, and they go to the orderly procedure, convenience of the courts. But the sign-off requirements are different. They try to meet the policy expressed in Cell versus United States at page 180. It says that these forced medication orders may be rare. These should be exceptions. And the sign-off requirement obviously is for some reviewing person and not a frontline doctor who signs orders all day long to issue this petition. And there's a violation of that provision in this case, and I think it's mandatory and not directory. And so because of that's basically what I want to talk about. I'll save the remainder of my comments for rebuttal. I ask that the court would reverse and send this back for a new hearing. Thank you.
Mr. Havlin.
Thank you, Your Honors. Can you hear me?
Yes.
Okay. I guess we'll start briefly just with the second assignment of error. I think in my brief, I point out the McClellan case, just noting that other parts of this statute have been found to not be jurisdictional. I don't think that's outcome determinative anyway, and I don't think we need to reach that. I believe Section B1C authorizes Dr. Daly in this case to request it as the treating physician or psychologist, whatever he is, the healthcare professional who is charged primarily with the treatment of the patient, I think can request it. And I think that makes sense, right? I don't know that we need, I don't know why you would want anyone else other than the person who's most familiar with the patient to request this. So unless there are any other questions on that, I'm happy to move on to the first assignment of error. On the standard of review, I think, so in my brief, I cite to this court's case, Jefferson. It's a similar fact pattern, similar procedural posture. I think we get to the same standard of review, but in that case, I'm sorry, this court said if we're on a manifest weight assessment, we get to the same words as Mr. Hoffman's clearly erroneous, I think is what it is. Basically, we want some competent, credible evidence to support the findings. All of the findings, I don't think it's contested that they're in the entry. Now we're just looking at the record to see whether or not there's some competent, credible evidence to support them.
And Mr. Hamlin, what about did the doctor go through each of the medications and kind of explain, here's what this one's for, here's the side effects of this one, here's why I think it would be appropriate, et cetera, et cetera?
He did not go through each one, no. And I don't know that there's an anticipation to use each one. I think if Judge Bergeron, you brought this up, he testified about the first.
But nonetheless, all were requested and all were approved. So even if there's no anticipation in using it, there was enough to request it and to approve it. It isn't like the doctor's going to come back again for the same medications. There's no need for the doctor to come back again. So
no, I don't think so.
I think we need to determine is whether that order as it stands, whether it complied with the cell's requirements, viewing it through our standard of review, of course.
And I think it does, Judge. He testifies that all of the medications on the list were appropriate to administer to a patient with schizophrenia and that they were appropriate for someone of the defendant's size, age, and weight. There's no extended cross-examination on any of those. The only question that was asked by defense counsel.
And I'm really focused on the fourth cell element, as I understand it. And so on the fourth one, it seems, to determine the administration is medically appropriate, it seems that that's where one would get into each medication.
I'm sorry.
Yeah, and maybe you feel differently. Maybe you'll say, no, Judge, it's the second, and that's fine.
I think at page 19 of the transcript, he says that all of them are medically appropriate for a patient with schizophrenia. He specifically talks more about Risperdal, which is the first-line treatment to which the defendant has been prescribed in the past. I think that's obvious. There's testimony in the record that says we only move off of that first-line treatment if there's an issue. I don't think there's a history of an issue in this. No, to answer the question, there is not testimony specific to every drug on the list. He does say that all of them are medically appropriate for this specific patient, a person with schizophrenia, but also someone of the defendant's size, age, and weight. There's no follow-up whatsoever on that question. The only question that's asked at the hearing is whether I guess the defendant has a history of migraines. There's a follow-up on that. If he takes Risperdal, is he still able to take medication for his migraines? And Dr.
Well,
Daly says, yes.
who had the burden? Who had the burden at the hearing?
The state did. There's no question there. And I think when he says all of these are medically appropriate for this specific defendant, I think that's met.
You think that meets both the second and the fourth elements? So with regard to like side effects and things like that, are you saying that none of that needs to be part of the record?
Well, he spoke about side effects also. He said, again, back to Risperdal, he said he's been prescribed this in the past, apparently without issue. He then says he's under 24-hour care. If any side effect is noticed, it can be addressed 24 hours a day. And he also states that they, on their regular meetings, or I'm not sure how it's phrased, it's revisited every time they chat, whether you're experiencing any new side effects and things like that.
On the record, do we know which medication is for side effects? Which are the ones that are for side effects, for example? Do we know that?
Let's see. I believe, I'm sorry, Your Honor, mood stabilization, antipsychotics, agitation, and the difficulty sleeping are the several itemized things, and that's in his letter. He goes through, this is page, I'm sorry, let's see. Yeah, I'm sorry. Transcript page 20 and 21, he states that number 15 through 17 are medications that can be used for possible side effects.
Mr. Havlin, getting back to the practical question that I asked Mr. Hoffman during his argument, like what happens here in a situation where the defendant gets restored to competency under this forced medication order, then is convicted of a crime? Like what happened? Does the forced medication order continue while he's in prison? For how long? Like how does that work?
So there's nothing in the record of this case, Your Honor, that states that. I don't think, if you look at the statute under which this order is made, it contemplates a return to competency, and that's all. I would guess, and I don't know this specifically in this case. I've known other, in a different job, I've had clients who have been incarcerated. I think that's a question for the institution once they've arrived. I don't.
Yeah, well, I mean, the reason I ask is that, like, usually it's not as if competency once restored is just permanent and there's no need for ongoing treatment. And so my concern, and this is more just kind of a policy question, but is what happens when this person goes to a prison and there's no forced medication and he then relapses to the prior state? Then we have the prison trying to manage someone who probably should be institutionalized in another setting. And
I don't know the answer to that, Judge. I don't know if there's a mechanism, if someone is an inmate that's akin to this, where, a warden or someone can petition someone for this type of order. I don't believe it will be this one. I have to think that this one expires upon the attainment of competency and then resolution of the case one way or the other. I think it specifically contemplates the restorative process. And that's all I really can say. I think I'm sorry, going to the second, I believe this is an argument, the second factor, these are all fairly interwoven. There's some testimony, I guess, about the use of the word hope versus the use of the word believe. I really think that's an argument about semantics. If you look at the record, Dr. Daly goes through the first, second, third line medications. He says that the first line medication would be Risperdal, that this patient has been prescribed that in the past, and that's what he would start with, barring any side effects or something unknown at the time. So I don't think.
Did he indicate that the prior use of Risperdal actually helped him in the past, or did he just say?
He only says prescribed. And so
Well,
I
I
think
think that was the issue in Jefferson, was he had, the individual, as I recall, had used the medication that was being requested by the doctor, and the doctor said, hey, look, this worked great for him when he was on it the first time. And I'm just curious, like, if he had previously been treated with this, like, why there was no explanation as to whether it, it worked, it didn't work, it kind of worked. I mean,
and I don't know if that's a function of so right, you can be prescribed to something and not take it, I suppose. I don't know. There's nothing in the record of this case of why it wasn't addressed more. I mean, I think it's fair to imply that he is no longer taking it, and that he is currently incompetent and not, and has an altered mental state. So I think, right. I mean, that, unfortunately, that's the extent of the information we have, is that he was previously prescribed. I think the inference there is that he's going to start with it again, so he has no indication that it doesn't cause him problems. But then he said, if, again, we regularly meet and reassess how it's going, and he has the opportunity 24 hours a day, should there be a side effect, to raise that, and then we will continue on. And he used the word hope. I don't think I would, I guess, kind of take issue with comparing this to repairing a car. He's a mental health professional with a client or a patient, I'm sorry, with schizophrenia. I don't know that absolutisms are appropriate in this field. I think when you look at past the word hope and look at what he says, he describes a regularly accepted course of treatment. And that's what he says he's going to attempt with this patient. And he says, without it, there is no chance of him being restored. There is testimony there about, there's a question about less intrusive means. He says there's really no purpose in sending someone with Mr. DiMarcia's current issues to group therapy sessions, because they're not really participating in reality. So you have to, this is the starting point if a restoration is going to be possible. I think if there are no additional questions, I think this record, if you look at Dr. Daly's testimony on the whole, does have some competent, credible evidence in it to support the findings made by the trial court. And I would ask that this court affirm that decision.
Thank you. Mr. Hoffman, you have about 3 minutes for rebuttal.
Thank you, Your Honor. I want to talk about the second assignment of error. I think this sign-off requirement is mandatory, and I think there's a jurisdictional defect here.
And have you found any cases that have said that, Mr. Hoffman? I didn't see any in the brief.
No, I did not.
Okay.
But the statute does set out, in the same statute, it sets out where a person can be committed in paragraph B, 1B. It says you can commit a person to a hospital, facility, or agency, a certified facility, a public or community mental health facility, a jail, or a psychiatrist. I mean, it tracks the same language as the sign-off requirement. And then the sign-off requirement mentions these facilities, and it says who should sign this petition when the person's committed to that particular kind of facility. And I think it's important. And I think that because this petition was not signed by the clinical chief clinical officer at Summit, where this person was committed, I think that's a defect. And I think it's a mandatory defect.
Getting back to Mr. Haviland's kind of response to this, don't we want the treating physician to be the one that comes forward with this and can testify about it? Because that person knows the specifics related to this patient, rather than the chief medical officer or whoever that would have no involvement in the treatment.
Well, sure, that he could be called as a witness. You call that person as a witness, but the actual petition would be submitted by his superior, by the person that reviews his work, by the person he's responsible to. The actual petition would be submitted by that person. That's the way the General Assembly set it up. I mean, it's clear. and-
Mr. Hoffman, you're ignoring, there is other language in there that says, or the person to which the defendant is committed for treatment. So how is that not the treating physician in the plain language of the statute?
Well, in the plain language of the statute, you go one subsection right above that, and it says that you can actually commit a person to a psychiatrist or mental health professional for treatment or evaluation. That's the person they're talking about in that added language you're talking about. That's when you commit a person to an individual for treatment and evaluation. That's what that language applies to. And if you're right, why would they have the other requirements? Why wouldn't it be a treating person instead of all the other people they mentioned in that? It would all be superfluous, all those requirements for a director or managing, director or a clinical officer, chief clinical officer. There'd be no reason to put that in there. I think there's something to this, and I think it's mandatory. That's why I'm spending the rest of my time on it, which I've just used up. So I'd ask that this court would reverse and remand for further proceedings. Thank you.
All right, thank you. Thank you both for your arguments this morning. The case is now submitted and we will issue a timely decision. And that concludes our Zoom arguments for today. Have a good rest of your day.